himself or herself and acting in his or her best interest. Consequently, a whole array of legal categories were generated to describe, justify or solidify the legal and by extension social incapacity of the person labeled mentally ill or deficient. Unsoundness of mind or mental infirmity or insanity, dangerousness, legal incompetence or diminished culpability, and sometimes lack of autonomy and self-determination, lack of legal representation, surrogate decision-making, and also the guardianship. It became the bulwark of mental health law. Ironically, what precisely constitutes an unsoundness of mind or insanity in the legal context was never defined with the judges, relying on the testimony of the expert witnesses, like the psychiatrists, in determining the existence or the impact. The courts did not distinguish between imputed disability and resulting incapacity. There was, however, no ambiguity regarding the non-person's status of the mentally disabled persons. Those placed under guardianship, for instance, lost of a person or property rights, and also confinement was deemed as the most suitable solution. So there could be postponement of civil and criminal trial allowed on grounds of insanity. You already know that the situation of persons with physical disability in the legal sphere was even more amorphous. And it is too soon to assess the impact of such a revolutionary paradigm shift on legislation and policy making at the national level. But international law mandates synchrony with local realities in due course. Prior to 1996, when the Persons with Disability Act or PWD Act was notified by the Government of India, cases involving physical disability were largely filed under Article 14, right to equality, and 21, right to life of the Constitution. As I already mentioned, mental disability was managed through a separate legal regime, that was the Leniency Act. In theory, the PWD Act adopts a rights-based approach to disability discrimination. It is a potential vehicle of change in a social context where disability is highly stigmatized and persons with disabilities massively excluded from the participation in mainstream society on an equal footing with their non-disabled counterparts. So when we look at disability, when we look at difference or the pursuit of equality, the stated objective of the current disability law regime worldwide is to achieve equality between the disabled and the non-disabled. Notions of formal and substantive equality are required to this end. These two separate approaches differ in how they negotiate with the notion of difference. Now, the formal approach, as you can see on the slide, to equality, the formal approach to equality, is concerned with equal treatment. That is, likes must be treated alike and unlikes be treated differently. In other words, the task of the courts when faced with questions of equal or unequal treatment of two individual or groups is to find out whether the individual or groups in question are similarly situated or not. Any finding of intelligible difference precludes any further inquiry of equality. In the formal approach, difference justifies differential treatment even if it is unequal in effect. For instance, segregated educational facilities for disabled children would be immune from an equality challenge under the formal approach, since there is the objective difference between disabled and non-disabled children. Now, the second approach, which is substantive equality, on the other hand, focuses on the actual impact of the law. Now, the debate here shifts from the question of sameness/difference on the issue of disadvantage owing to the difference. Here, any equality analysis takes into account the question of or the context of systemic and institutional exclusion or subordination and attempts to remedy it substantially. In case of the disabled, this implies taking into account both the social barriers to participation as well as limitations posed by the body or the impairment. However, pursuing substantive equality for the disabled does not mean that the question of sameness or difference is irrelevant, but in fact it entails recognizing the actively engaging with the difference, albeit for the different purpose. The substantive approach for disabled hence demands that difference is accommodated rather than ignored or assimilated. So the question as to how difference is appreciated, conceived and accommodated in law is central to the project of achieving equality between the disabled and the non-disabled. In case of the disabled, where the difference is located in the body or in terms of the restriction of the activity, how does the principle of equality operate? And how equality between the disabled and the non-disabled negotiated and ensured in the judicial discourse. Now, the judicial construction of difference is colored by the cultural notions and the stereotypes about the disabled, and also medical knowledge, which in turn influences the models of equality pursued. The first step in this process is to determine the nature and extent of difference between the individuals or groups in question. The need for evidence being central to the legal process. Of course, the medical discourse is instrumental in validating and identifying the difference. Further, since ensuring substantive equality for the disabled requires recognizing and accommodating difference. Facilities such as ramps or accessible transport, disabled-friendly laboratories in public buildings, and other infrastructural modifications become central to the enforcement of equality. Also, faced by the resource constraints, courts often restrict the availability of the state assistance to only a few categories of disabled people. So the focus of the judge then is not on the existence of the impairment, but on the level of vulnerability and the actual need for support necessitated by the impairment. So this involves the question of securing equality not only between the disabled and the non-disabled, but also among various categories of disabled people themselves. This once again indicates that the pursuit of equality is contingent upon how difference is construed by the law and the judicial discourse. Now, much of the social policy, including law, is driven by the notion of disability as a personal tragedy which needs to be compensated. Such a view is underlined by the construction of disability as an individual problem located in the body of the disabled person. The focus on the individual body is not, it not only flags themes of need and capacity, but also accentuates the process of medicalization and a frequent undermining of the role of social factors in the genesis, in the definition and management of disability. Medicalization could be defined as the process of applying medical knowledge to individual and social problems and establishing medicine as an instrument of their management and control. In the context of disability, the medical model, which we discussed in quite a few classes while reading Oliver, it has played a fundamental role in the categorization and labeling of bodies as normal or pathological. deformity with an assumed form of normality, which is more often than not the condition or perception of the majority. Recently, I was watching this documentary on genetic selection, and there is a huge debate about the ethical debate here. There is a huge ethical debate, and genetic selection also because parents do not prefer children with disability. Given a choice, actually nobody would prefer. So there were several interviews, and one interview was from a person who was apparently suffering from the disability of being a dog, people with small stature. So, and she said that what if we want to be like this? The genetic selection is offering a solution of not being a dog, but this is what we are. And if we are already in a minority, and we would become a minority if people take it. Because if you go to genetic selection, I think not that I would say that I have anything against or anything in support of it, but it's going to be very monotonous society. Anyway, this is a different kind of a debate. But here, as Mike Oliver, in the context of disablement, argues, the disabled individual is an ideological construction related to the core ideology of individualism and the peripheral ideologies of medicalization and normality. An important consequence of medicalization in the context of judicial adjudication of disability is the important role accorded to the medical professional in mediating the relationship between the state and the disabled people. Medical assessment determines who was deserving the legal entitlement, protections and welfare benefits. So the PWD Act classifies disability into 7 categories, namely blindness, low vision, leprosy cure, hearing impairment, locomotor disability, mental retardation, and mental illness. And I've seen as an MA admission in charge in my department, I have seen that from your batch onwards, several categories have been added for admission only for disabled people, which were not there earlier. And as I informed in the previous class, now the PWD is known as PWD, which is persons with this benchmark disability. So several things has changed since then. Further, there are medical parameters defining each category of impairment for a person to avail the rights and protections under the Act. He or she must be certified as medical authority as having at least 40% disability. So this, locating and understanding of the process of medicalization in the judicial discourse is crucial to unravel that what conditions are recognized as disabilities and who is the subject of disability law. Such medically inspired schema of the Act has been criticized by the activists for all those disabled persons who do not fall within the strict parameters of these 7 categories are not entitled to the protection of that. Another criticism of such a medicalized definition of disability is that a singular focus on impairment for the purpose of legal redressals that prevent participation of the disabled in society. Medical interpretations of disability are deployed to buttress claims and counter claims in disability adjudication. They also highlight the impact of such pervasive medicalization on the legal rights of disabled persons. So other significant theme running through the judgments is that of capability. It's very subjective word actually. The Oxford Dictionary defines capability as the power or ability to do something. So capability is a contested concept, as it is often colored by the stereotypical notions about the disabled being unproductive and dysfunctional. Such stereotypes are often at play in judicial decisions relating to education and employment opportunity. Now, capability as a concept is grounded both in the socio-cultural notions of disability and productivity and the medical resource. The association of disability with the lack of productivity is attributed to the rise of the industrial capitalism in the West and the attendant mechanization of labor and the new forms of production which were unfavorable to the disabled. The replacement of home and community-based production with the factory as a site of production meant the removal of the disabled from the economic process and their relocation into institutions and sheltered workshops. So the construction of the disabled as without capacity is further entrenched by the pervasive medical determinism in the diagnosis of disability, which gives rise to the reductionist views about the abilities. The judgments show that the judicial attitude of the thresholds of capability is influenced to a large extent by the opinion of the medical professionals, irrespective of whether the functional ability of a disabled person in a specific situation is at all affected by the presence of or absence of the impairment. As it appears, there is an assumption of a normative person with a certain range of abilities, capacities, and capabilities deemed normal. So this unstated norm is subtly invoked in the most enlightened judgments that view disability as primarily inflected by social concepts. So again, coming back to the PWD Act's recognition of specific categories of disability raises the issue of differential levels of needs and assessment and extension of vulnerability. Again, the homogeneity of disability proposed by the disability rights movement and to some extent endorsed by the CRPG is put to the test when claims and counterclaims are made by persons having different disability. Now, such cases reconfigure the sub-quotas within quotas, debate on an ethically flawed context, where suffering and injustice are tried on the pragmatic grounds. Now, the medicalization of disability. So, medicalization is a keynote of disability in the law in the Indian context, even when it is challenged in the course of adjudication. So, in this section, we can see that we will illustratively highlight how medicalization pans out in the concrete cases. It will be noticed that even though medical criteria are central in enabling a person to stake claims on the ground of disability, in the majority of cases, medicalization helps in maintaining the status quo by working against the claims of petitioner. I have taken it from an essay which I'll share with you later. Now, one reason for this universality of biomedical categories is seriously undermined in actual practice due to frequent disagreements among experts. Now, when this happens in the judicial context, it can complicate the situation even more with serious implications for the legal rights of the disabled person. In the face of conflicting medical opinions, judges have been found to creatively take recourse to more contextually based notions of disability and capability, thus questioning the often taken for granted equivalence between medical and legal definitions of disability. So I will just share one case with you, such, which is Naveen Kumar versus University of Delhi. I found it relevant to mention there are many cases, but this is something I think you can understand. In Naveen Kumar versus the University of Delhi case, Naveen Kumar is a physically challenged person using a wheelchair, and he was denied admission to the Bachelor's of Engineering in Computer Science course on account of his impairment. Now, this petitioner had secured a rank of 5,016 out of 25,000 in the entrance test, and hence he was eligible for admission. In the court, the respondent, the University of Delhi, argued that Kumar was so badly handicapped that he would not be able to undertake the requirements of the course successfully. And thus, as a result, it would amount to an unnecessary blocking of a seat, which could have otherwise benefited to another deserving candidate. While the court stressed the statutory obligation of Delhi University to pursue the affirmative action and granted that the petitioner was entitled to be considered for the seats reserved for the disabled, the court actually refrained from commenting directly on the question of Kumar's ability to pursue the course in the light of his impairment. Instead, the court directed the medical officer or MO of the university to examine him and find out whether his impairment would prevent him from pursuing the course. So the MO was specifically directed to take the petitioner to the workshops and laboratory and observe on him that while working on machines, he would neither be endangering his own life and limbs nor the ordinary courses of his presence to pursue study cause damage to the instruments and other apparatus in the laboratory and workshops. So, the judge disposed of the case by directing the university to decide the question of admission on the basis of medical examination within a stipulated period of time. This case illustrates one of the central criticisms against the medicalization of this unit. The judge proceeded on the assumption that the problem rested in the impairment of the petition. And this is why we were discussing about the difference between the impairment and disability. Right? And then said to depute a medical authority to assess whether Naveen Kumar would be able to meet the demands of the course and whether his impairment would prevent him from accessing the laboratory or workshop, etc. An alternative judicial course of action in this case would have been to direct the university to implement the provisions of the European Act, which provides for changes in the curriculum and the adaptations in the built environment to facilitate the exercise of rights of the disabled. So think about this case if you can come up with that. So that is all by me for today.